Unit 7, Federal and State Laws, Fair Housing, ADA, ILSA, Landlord-Tenant Basics. Hi, I'm Anisha, your AI study partner with License to Learn. Before we get started, I want to thank our sponsor, License Closet, for supporting this video. License Closet offers an affordable way to hang your real estate license for just $149.99 per year with no MLS required. This is a great option for agents who want to stay active, keep learning, and build at their own pace. You'll find the link below. This video is for educational purposes only. Florida real estate laws, rules, and procedures can change, so always verify current requirements through official Florida sources before relying on this information. This content is Florida specific and is a study guide, not a substitute for completing a state-approved course. Now, let's get into today's lesson. Unit 7, Federal Plus, Florida laws that keep real estate fair and landlords legal. Let's lock in Unit 7. This unit is basically the rules of the road for how we treat people in housing, plus Florida's landlord-tenant basics that show up on the state exam. 2 big buckets today. 1, fair housing laws, Federal plus Florida, who's protected, what's illegal, and what gets tested. 2, Florida Residential Landlord and Tenant Act, deposits, notices, access, and eviction steps. Quick promise, I'm going to teach it like a smart friend. But we're staying sharp like an instructor, because the exam loves the details. Part 1, the old but powerful law, Civil Rights Act of 1866, plus Jones versus Mayer. Think of the Civil Rights Act of 1866 like a permanent no racism allowed sign on property sales. The key idea, racial discrimination in property sales can be illegal even when it's private people doing it. That's where the famous case comes in, Jones v. Alfred H. Mayer, 1968. This case is the reason your instructor says fair housing isn't optional. Exam-style question. What did Jones v. Mayer basically confirm? Answer. It confirmed that federal law can prohibit private racial discrimination in the sale or rental of property. Remember it like this. Even if it's my house, you can't run your sale like a private club if the reason is race. Part 2, Fair Housing Act, 1968, plus 1988, amendments, the exam's favorite list. Now the big one, the Federal Fair Housing Act. The exam usually wants you to memorize the protected classes and recognize illegal behavior. Protected classes you must know, the classic exam list. Race, color, religion, sex, national origin, familial status, disability. Exam style question. Which 2 were added by the 1988 amendments? Answer. Familial status and disability. Also know most housing is covered. So on the exam, assume it applies unless an exemption clearly fits. Part 3, exemptions, the don't get tricked zone. The Fair Housing Act has exemptions, but the exam uses them like trapdoors. Know the big ones. 1, owner-occupied building with 4 units or fewer, the Mrs. Murphy style exemption. 2, single-family home sold or rented by the owner without a broker and usually with limits. 3, housing run by religious organizations or private clubs, limited situations. Exam-style question. If an owner is exempt, does that mean they can advertise discrimination? Answer, no. Discriminatory advertising is still a major problem and can trigger liability. How to think about exemptions. Exempt doesn't mean free to be unfair. It means limited coverage, not no consequences. Part 4, What's Illegal? The How You Get Sued list. The Fair Housing Act bans discrimination in selling, renting, and related services. These are the classic prohibited acts the exam loves. Refusing to rent or sell. Offering different terms, chats, conditions, different rent, different deposit, different rules. False statements about availability. It's already rented when it isn't. Discriminatory advertising. Steering, guiding people to or away from areas because of a protected class. Blockbusting, panic selling tactics like those people are moving in. Redlining, denying services, loans, insurance based on neighborhood demographics. Exam style, question. What is steering? Answer. Trying to direct buyers, tenants toward or away from certain neighborhoods based on protected class reasons. Street smart reminder. Your job is to provide options based on criteria like budget, commute, schools chosen by the client, property features, not identity. Part 5, Disability plus Familial Status, where the exam gets specific familial status. There are families with children under 18, plus pregnancy, plus people in the process of getting custody. You can't say no kids, adults only, or perfect for singles only in a way that excludes families. Disability, physical or mental impairment that substantially limits major life activities, plus record of it or being regarded as having it. Here's the key exam distinction. Reasonable accommodation. Change a rule, policy, service. Reasonable modification. Physical change to the property. Exam style. Question. Tenant asks, can I have an assistance animal even though it's a no pets building? That's what? Answer. A reasonable accommodation, policy exception. Exam style question. Tenant asks, can I install a grab bar? That's what? Answer. A reasonable modification, physical change. Also know housing for older persons rules. Some 55 plus communities can be exempt from familial status rules if they meet specific requirements. Part 6, Housing for Older Persons, 55 plus, the 80% rule. Here's the exam-friendly version. For a community to qualify as 55 plus, housing for older persons, it must truly be intended and operated for older persons. The number the exam loves. At least 80% of the occupied units must have at least one person who is 55 or older. Exam style. Question. What's the 55 plus occupancy threshold? Answer. 80% of occupied units must be occupied by at least one person age 55 plus. Important. This is an exemption from familial status discrimination rules. Not a do whatever you want pass. Part 7, Enforcement plus. Liability, who can get in trouble? Fair housing enforcement can involve complaints filed with the U.S. Department of Housing and Urban Development, civil suits in federal court, U.S. Department of Justice involvement, pattern, practice, or public importance. Florida also has its own fair housing law, Florida Statutes, Chapter 760, Part 2. And Florida's state-level agency role is handled through the Florida Commission on Human Relations process. Exam-style question. If a sales associate follows a discriminatory instruction from a seller, are they safe? Answer. No. Licensees can have responsibility and liability for fair housing violations. Real-world truth. If you participate, you can be named. Part 8, Americans with Disabilities Act, ADA, the Public-Facing Places, Law. The ADA is different from the Fair Housing Act. The ADA is about access in places open to the public and commercial facilities. Think leasing office, sales office, open house setup, model home tour paths, showings in a business context. Title III covers public accommodations and requires new construction alterations to meet accessibility standards. Exam style question. Does the ADA focus on housing discrimination or public access? Answer. Public access, places of public accommodation and commercial facilities. Exam tip. Fair housing. Who can buy, rent, and under what terms? ADA. Can they physically access the place when it's a public-facing business setting? Part 9. Interstate Land Sales, Full Disclosure Act, ILSA. The Subdivision Fraud Shield. ILSA is basically the truth in advertising law for selling lots in certain subdivisions. It requires registration and disclosures for developers selling or leasing non-exempt lots. The key exam number. A subdivision containing 100 or more non-exempt lots triggers the registration program. The key exam document. The property report must be given to the buyer before a contract is signed. Exam style question. Which agency oversees the ILSA registration program? Answer. The Consumer Financial Protection Bureau. ILSA memory hook. If someone is buying dirt in a big subdivision, ILSA wants paperwork before promises. Part 10. Florida Residential Landlord and Tenant Act, deposits, plus notices, plus access. Now Florida's Landlord-Tenant rules. Florida Statutes, Chapter 83, Part 2. This is the part where the exam tests timelines like a stopwatch. Security deposits, big timelines. If no claim, landlord must return the deposit within 15 days after tenant vacates. If landlord plans to make a claim, landlord must give written notice within 30 days after the tenant vacates. Tenant then has 15 days after receiving that notice to object in writing. Exam style question. Deposit return timeline if no claim. Answer. 15 days. Exam style question. Landlord claim notice deadline after move out? Answer. 30 days. Exam style question. Tenant objection window after receiving claim notice? Answer. 15 days. Landlord access. For repairs, reasonable notice is at least 24 hours and entry should be at a reasonable time. Exam style question. Minimum notice for repair entry? Answer. 24 hours. Part 11, termination plus eviction basics, Florida exam favorites. Terminating a periodic tenancy, no set end date. Year to year, at least 60 days notice. Quarter to quarter, at least 30 days notice. Month to month, at least 30 days notice. Week to week, at least 7 days notice. Exam style question. Month to month termination notice. Answer. At least 30 days. Default eviction notice types you'll see on the exam. Non-payment of rent. 3-day notice, excluding weekends, holidays, and how it's counted in practice. Know the concept. Non-compliance that can be cured. 7-day notice with opportunity to cure. Serious non-compliance, repeat issues. 7-day notice without opportunity to cure. Active military special rule, Florida. A service member can terminate a rental agreement in qualifying situations with written notice effective at least 30 days after the landlord receives notice. Exam style. Question. Service member termination effective date rule? Answer. At least 30 days after landlord receives notice, if criteria are met. Rapid exam drill. Answer out loud, then check. 1. Name the 7 classic fair housing protected classes. Answer. Race, color, religion, sex, national origin, familial status, disability. 2. Which 2 were added in 1988? Answer. Familial status and disability. 3. What is steering? Answer. Directing buyers' tenants toward or away from neighborhoods based on protected class reasons. 4. What's the 55 plus threshold number? Answer. 80% of occupied units must include at least one person age 55 plus. 5. ILSA triggers at what subdivision size? Answer. 100 or more non-exempt lots. 6. Who oversees ILSA registration? Answer. Consumer Financial Protection Bureau. 7. Security deposit return deadline if no claim? Answer. 15 days after tenant vacates. 8. Landlord claim notice deadline after move out? Answer. 30 days. 9. Tenant objection window after receiving claim notice? Answer. 15 days. 10. Repair entry minimum notice? Answer. 24 hours. Recap. This unit is about fair access to housing legal behavior in Florida's timeline-based landlord-tenant rules. Welcome to Key Terms, where we turn real estate words into real estate understanding. Let's begin. Unit 3 is the license rules backbone. If Florida Real Estate had a control room, this unit is who's in it and what levers they pull. Key Term 1, Department of Business and Professional Regulation, the Department. This is the state department over professional licensing, including real estate. It's the umbrella. Key Term 2, Florida Real Estate Commission. This is the real estate rule and discipline board that exists within the department. They create rules, approve education, and handle violations. Key Term 3, Division of Real Estate. This is the operations engine. It provides record keeping, exam services, legal services, investigative services, and other support needed to regulate real estate. Check-in question. Who provides exam and investigative services for Chapter 475 regulation? Answer. The Division of Real Estate. Key Term 4, Florida Real Estate Commission, membership makeup. The exam likes the structure facts. The commission has 7 members appointed by the governor and confirmed by the Senate. 4 must be licensed brokers with an active license for the 5 years before appointment. 1 must be a licensed broker or sales associate with an active license for the 2 years before appointment. 2 must be consumer members who are not and never have been brokers or sales associates. At least 1 member must be 60 years old or older. Check-in question. How many total members are on the Florida Real Estate Commission? Answer. 7. Wrong answer magnet. People mix up 7 members with 7 brokers. Not true. 2 are consumer members and only some are brokers. Key Term 5, Active License. Active means you can legally perform real estate services as long as you're properly registered for associates under a broker. Key Term 6, Voluntarily Inactive. You chose to be inactive. You're not practicing, but you're not in trouble. Key Term 7, Involuntarily Inactive. This usually happens when you do not renew on time. You're not practicing, and you must meet statutory requirements to get active again. Key Term 8, Null and Void. This means the license is dead. Not inactive, not late. It's expired by operation of law, and you generally must requalify to get licensed again. Check-in question. If a license has been involuntarily inactive for more than 2 years, what happens? Answer. It automatically expires and becomes null and void. Key Term 9, Multiple Licenses. A broker may request additional broker licenses if needed for business, and the commission can approve or deny. A sales associate or broker associate cannot have more than 1 registered employer at a time. Check-in question. Can a sales associate work for 2 different brokers at the same time? Answer. No. A sales associate and broker associate may have no more than 1 registered employer at any one time. Wrong. Answer magnet. People hear multiple licenses exist and assume it applies to sales associates. On the exam, multiple license rules are mainly a broker topic. Key Term 10, Post-Licensure Education, Post-License. This is the education you must complete before your first renewal after initial licensure. Numbers you must know. Sales Associate Post-Licensure, up to 45 classroom hours, 50 minutes each. Broker Post-Licensure, up to 60 classroom hours, 50 minutes each. The consequence, the exam loves. If you do not complete post-licensure before the first renewal, your license is considered null and void. Check-in question: what happens if a sales associate misses post-licensure before first renewal? Answer: the license becomes null and void, and the person must requalify, pre-license plus state exam, to be licensed again. Bonus exam detail: the Commission may allow an additional 6-month period after first renewal for post-licensure completion in individual physical hardship cases, as defined by rule. Key term 11. Continuing education, renewal education. After the first renewal cycle, Florida requires continuing education for every renewal biennium. The statutory baseline, 14 classroom hours, 50 minutes each biennium. Florida Real Estate Commission education breakdown, exam friendly. 3 hours core law, 3 hours ethics and business practices, 8 hours specialty education. Key term 12. Legal agenda credit substitution option. 1 time per renewal cycle, the Commission may accept attendance at 1 legal agenda session as a substitute for 3 classroom hours. To get credit, you must notify the Division of Real Estate at least 7 days in advance. And you cannot get credit if you are attending as a party to a disciplinary action. Check-in question: how many hours of continuing education are required each biennium after first renewal? Answer: 14 hours. Key term 13, reactivation education, getting back from involuntary inactive. If involuntarily inactive for 12 months or less, you may reactivate by completing at least 14 hours of a commission-prescribed continuing education course. If involuntarily inactive for more than 12 months but fewer than 24 months, you may reactivate by completing 28 hours of a commission-prescribed education course. If involuntarily inactive for more than 2 years, the license automatically expires and becomes null and void. No further action needed. Hardship reinstatement after void. If the Commission determines the failure was due to illness or economic hardship as defined by rule, it may reinstate, but you must apply within 6 months after the license becomes void. Check-in question: involuntarily inactive for 18 months, how many reactivation hours? Answer: 28 hours. Key term 14, license ceases to be in force, change triggers plus 10-day rule. A license stops being in force when a broker changes business address, or a sales associate changes employer, or a school changes address, school instructor side. The deadline: the licensee must notify the Commission no later than 10 days after the change using the Commission's form. Key term 15, group license, used for an owner-developer who owns properties through multiple connected entities. A sales associate or broker associate may have a group license to sell for all the entities owned by that owner-developer. Key term 16, professional entity licensure, sales associate, broker associate. A broker associate or sales associate can be licensed as an individual or, with required authorization, as a professional corporation, limited liability company, or professional limited liability company. Final rapid drill. 1. One registered employer at a time applies to who? Answer: sales associates and broker associates. 2. Post-licensure hours for sales associates. Answer: 45 hours, max prescribed. 3. Notice deadline for employer address change. Answer: 10 days. Before you go, make sure you like, subscribe, and share this video with anyone who's preparing for the Florida real estate exam. If this lesson helped you, that tells me I'm doing my job. And if you're ready for more structured support, live instruction, and accountability, you're invited to join our online classes through License to Learn. You'll find the sign up link below. Keep showing up, keep studying, and keep building the future you're working toward. I'll see you in the next lesson. Florida laws and rules can change. Verify the most current requirements through the Florida statutes, Florida Administrative Code, DBPR, and the Florida Real Estate Commission.